followed by the national anthem.
In the name of Father, Son, and Holy Spirit, amen. Father in heaven, we ask for your wisdom as we begin this meeting. We acknowledge that we need your wisdom and insights, and we welcome your presence among us. Guide us in our discussions and decisions, helping us to seek what is best for all involved. We trust in your perfect wisdom, and we ask that you direct our meeting according to your will. In James paragraph 1, verse 5, it says, "If any of you lacks wisdom, let him ask God, who gives generously to all without reproach, and it will be given to him." We claim this promise as we start our meeting and trust in your provision. Thank you for being with us always. Amen.
Bayang magiliw, perlas ng silanganan, hanap ng puso, sa dibdib mo'y buhay. Upang hilirang, duyan ka ng magiting, sa manlulupig, di ka pasisiil, sa dagat at bundok, sa simoy at sa langit mong bughaw. May hilag ang tula at awit sa paglayang minamahal, ang kislap ng watawat mo'y tagumpay na nagniningning, ang bituin at araw niya kailan pa may di magdidilim. Luha ng araw ng luwalhatit magsimba, buhay ay langit sa piling mo. Aming ligaya na pag may mga api, ang mamatay ng dahil sa'yo.
Everybody may take their seats. The first regular meeting of the Committee on Justice in the 20th Congress is hereby called to order. Considering that this is the first meeting of the Committee on Justice in the 20th Congress, the committee secretary is hereby directed to call the roll of members.
Madam Chair.
Vice Chair Keith Flores is recognized.
Madam Chair, I move to dispense with the calling of the roll.
The calling of the roll is hereby dispensed with. May we acknowledge the members present, Committee Secretary.
On behalf of the Committee on Justice, we would like to acknowledge the presence of the following members: the Honorable Chairperson, Attorney GERVILLE, JINKY BITRICS, R. LUISTRO. The Honorable Deputy Speaker, Francisco Paulo P. Ortega V. Vice Chairpersons, Mauricio G. Domogan, Attorney Danilo Danny A. Domingo, Jennifer A. Lagbas, Brian Poe, Jonathan Keith T. Flores, and the regular members of the committee, Honorable Joel R. Chua, Lordan G. Suwan, Bernadette S. Barbers, and Jose Manuel Tadeo Chel I. Diokno.
Thank you, Comsec. Now we will hear the opening remarks of the Chair. Good morning to my esteemed colleagues, our distinguished Vice Chairpersons, and the regular and ex officio members of the committee. Welcome to the organizational meeting of the House Committee on Justice. Allow me first to acknowledge the presence of the following members of the committee. The Honorable Deputy Speaker Francisco Paulo P. Ortega, the Fifth. Vice Chair Honorable Mauricio G. Dumogan. Vice Chair Honorable Jennifer A. Lagbas. Vice Chair Honorable Brian Poe. Vice Chair Honorable Jonathan Keith Flores. For the regular members, Honorable Joel R. Chua, Honorable Lordan Suan, Honorable Bernadette Barbers, and for the minority, the Honorable Jose Manuel Tadeo Chel Jokno. Thank you all for coming. We shall first formally organize the committee by adopting the internal rules of procedure as mandated by Section 34 of the Rules of the House of Representatives. For the benefit of the new members of this committee, allow me to provide a brief overview of the jurisdiction and functions of the Committee on Justice. The Committee on Justice is one of the standing committees in the House of Representatives. Under Section 28 of the Rules of the House of Representatives, this committee has jurisdiction over all matters directly and principally relating to the following. Number one, the administration of justice. Number two, the judiciary. Number three, the practice of law and integration of the bar. Number four, legal aid. Number five, penitentiaries and reform schools. Number six, adult probation. Number seven, impeachment proceedings. Number eight, registration of land titles. Number nine, immigration, deportation, and naturalization. And finally, number 10, the definition of crimes and other offenses punishable by law and other penalties. Under the rules, the committee shall be composed of 55 members. At present, we have 35 members, led by this representation as chairperson, with the following vice chairpersons. Vice Chairperson Mauricio G. Dumogan from the Lone District of the City of Baguio. Vice Chairperson Attorney Danilo Dani A. Domingo from the 1st District of Bulacan. Vice Chair Jennifer A. Lagbas from the 1st District of Misamis Oriental. Vice Chair Alfredo A. Garbin Jr. from the party list Ako Bicol. Vice Chair Brian Poe from the party list FPJ Panday Bayanihan. Vice Chair Jose C. Alvarez from the 2nd District of Palawan. Vice Chair Jonathan Keith T. Flores from the 2nd District of Bukidnon. And Vice Chair Isabel Maria J. Zamora from the Lone District of the City of San Juan. Under the rules, 1/5 of the total membership of the committee shall constitute a quorum to do business. And since we only have 35 members as of today, quorum shall consist of 7 members, while majority of all members, whenever required by the rules, shall be at least 18 members. However, a simple majority of the members present is required for the committee to approve ordinary motions in the conduct of ordinary business, such as the approval of bills, committee reports, and others. As of August 20, 2025, there are 137 measures referred to this committee, and we are expecting more measures as the first regular session of the 20th Congress moves along. Nevertheless, as your chair in this committee, I commit to be a working chairperson and shall endeavor to hear as many measures as possible to make the 20th Congress a very productive one under the leadership of our very focused and hardworking Speaker Ferdinand Martin Romualdez. Thank you. Before we proceed, we would like to recognize the presence of the Honorable Congressman Munir M. Arbison from the 2nd District of Sulu. We would like to recognize as well the Honorable Congresswoman Ana York P. Bondoc from the 4th District of Pampanga. Thank you for coming. We will now proceed to the first item in our agenda, which is the approval of the internal rules of procedure of the Committee on Justice in the 20th Congress. The Secretariat has distributed the copy of the internal rules of procedure, and we anticipate that the members are done in going through the same. So if there are no proposed amendments, the chair would like to solicit a motion for the approval of the internal rules of the committee.
Madam Chair, I move that we approve the internal rules of procedure of the
Please
Committee on
wait
Justice
to be
in the
recognized,
20th.
Congressman.
Yes.
Congressman Joel
Sorry,
Chua.
Madam Chair.
We recognize Congressman Joel Chua.
Thank you, Madam Chair. Madam Chair, I move that we approve the internal rules of procedure of the Committee on Justice in the 20th Congress.
There is a motion for the approval of the internal rules of procedure of the Committee on Justice. Is there?
Second.
The same has been seconded. Is there any objection? Hearing none, the internal rules of procedure of the Committee on Justice in the 20th Congress is hereby adopted unanimously. The committee secretary is directed to transmit a copy of the adopted internal rules to the Committee on Rules pursuant to Section 34 of the Rules of the House of Representatives. At this point, we will now proceed to the item Other Matters. There is now before the committee a letter signed by the Honorable Congressman Percival Sendanya requesting the Committee on Justice to conduct an inquiry in aid of legislation on the reported request of the United States government on the extradition of Pastor Apollo C. Quiboloy. May I request for a copy of the letter? Please let the chair read the letter. Chairperson, Committee on Justice, Dear Madam Chair, this is dated August 23, 2025. In light of the reported request of the United States government for the extradition of Mr. Apollo Quiboloy, I respectfully urge the Committee on Justice to conduct an inquiry in aid of legislation on this matter. There is an overwhelming public interest and concern over the process by which extradition requests are received, evaluated, and acted upon. It is imperative that Congress, through your committee, provide a forum where concerned agencies may clarify the status of the present request, explain the legal and procedural steps involved, and identify any gaps or ambiguities in our existing laws and treaties. This inquiry will not only help ensure transparency, fairness, and adherence to our international obligations, but also allow Congress to determine whether remedial or supplemental legislation is necessary to strengthen the country's extradition framework. Thank you for your attention to this request. Respectfully signed by the Honorable Percival Sendanya. May I direct the committee secretary to provide the members with a copy of this letter. With regards to this request of the Honorable Percy Serdanya, that a motu proprio inquiry in aid of legislation be conducted on the extradition of Pastor Apollo C. Quiboloy, we are opening the floor for the comments of our committee members. The Honorable Joel Chua is recognized.
Thank you, Madam Chair. Madam Chair, I only have two issues with respect to the extradition of Mr. Apollo Quiboloy. My first question, Madam Chair, is that will extradition be considered by the requesting party while there are still pending cases against Mr. Quiboloy in the Philippines?
With the limited knowledge of the chair, upon reading of the treaty between the United States and the Philippines, it appears that even when there is pending cases in the requested party, the requesting party can initiate an extradition process in the Philippines. Congressman Chua?
Thank you. My second question is with respect to the timeline, Madam Chair. The timeline between the receipt by the Department of Foreign Affairs of the requested extradition of Mr. Apollo Quiboloy and the transmittal to the Department of Justice, and the timeline from the receipt by the DOJ to the filing of the petition for extradition.
For the guidance of all the members, there are two significant laws which must be considered in the discussion of this extradition. One is the treaty that was entered into by the United States government and the Philippine government back in 1994. The other one is PD 1069, which is the Philippine extradition law passed by former President Marcos Sr. back in 1977. If I will be basing my answer to the question of the Honorable Chua, in both laws, it is silent with respect to the timeline between the receipt of extradition by the DFA to its transmittal to DOJ, in the same way that it is silent with respect to timeline from the transmittal to DOJ to the filing of petition for extradition with the regional trial court. The Honorable Vice Chair Dumogan is recognized.
Thank you, Madam Chair. With all due respect to, of course, our colleague who made this letter, at this point in time, I do not know if it is proper for this committee to take jurisdiction over this issue when these are covered by our treaty between the government in the United States and, of course, existing laws of the Philippines. I do not have any doubt that the existing laws on extradition will be followed by the concerned agencies. So what will this committee do at this point in time when we have a lot of urgent matters that the committee should pay attention to? To me, as I said, at this point in time, there's no somewhat urgency for us to conduct an inquiry on this issue. Thank you, Madam Chair.
The
Madam Chair.
Honorable Vice Chair Keith Flores is recognized.
Madam Chair, well, it is true the comments made by Congressman Dumoga. No? I also agree with some of it. No? But I also would like to know din na marami pa kasing questions when it comes to extradition. Na it's not really much of a siguro dinidiscuss na topic even in our jurisprudence. No? So, example lang po, I have a question like, kung may request for extradition ba, who will have jurisdiction? Is it the court that's hearing the case where the person who is requested to be extradited? Or is it another RTC court? No, these are things na siguro by taking it up in our committee, we could help define. No? We could help siguro refine. Kasi as the chairperson nga mentioned, it's based on a law that's made in 1977. No? So revisiting it would not necessarily mean that we are infringing on any of the activities being undertaken by the courts. No? It's determining what can be done in the future, not in the present case of Pastor Quiboloy, Madam Chair.
Thank you. Any other member who wish to comment?
Yes, Madam Chair, may I be recognized?
The Honorable Chel Jokno is recognized.
First of all, may I put on record that I fully support the request of Representative Sendanya. Just for the information of the Chair and the members, there is an article in the Philippine-U.S. Extradition Treaty that provides for what is known as temporary surrender. This refers to a situation where the person subject of extradition has a pending case or cases in the Philippines, but is being extradited to face cases also in the United States. And as based on what I recall of that provision, the person subject of extradition may be brought to the United States to face the cases there and then returned to the Philippines after to continue with the cases that are pending here. Before the hearing today, I inquired as to the status of the cases pending in the Philippines, and I was informed that most, if not all, of the victims have already testified. Tuloy pa po ang trial. The defense has not yet proceeded with its evidence, but given that situation, I think it would not be a problem for us insofar as the victims here, since they have already testified. I would also agree with the observation made by the Honorable Chair that perhaps we could look back at the presidential decree because it does not provide for specific timelines. At the same time, we may want to know from the judiciary if there are specific rules that govern the periods for which to decide extradition cases. Thank you, Madam Chair.
Thank you, the Honorable Jokno.
Madam Chair.
Honorable Flores is recognized.
Also in relation to what Congressman Jokno just mentioned, yung temporary surrender tsaka deferred surrender, even in the laws on the PD, it does not really state kung sino, who will make the determination po. And that's why I think that there is actually a need to look into the old PD. Now, it's not necessarily in the context of Pastor Quiboloy, because it's going to be moving forward now with what we can do in probable amendments to this particular presidential decree. Kasi nga po, let's say, who chooses whether it's temporary surrender or deferred surrender. Other than the timeline, no? So, sino ang mag-decide on that? The PD does not say so, no? So, as far as yun sa nabasa ko, no? So, again, siguro tama lang din po na bisitahin natin ulit, no? And revisit it and discuss it again in the form of an inquiry, no? In aid of legislation para makorek din natin tong gaps that are existing in the current PD po.
Any other member? Of course, we conform to the insights and positions which were shared by the Honorable Jokno, the Honorable Chua, the Honorable Kit Flores, and we consider as well the sentiment of the Honorable Dumogan. But with regards to the issue of urgency and propriety that was raised by the Honorable Vice Chair Dumogan, I wish to respond that it is within the jurisdiction and purview of the Committee on Justice to revisit our extradition law by way of an inquiry in aid of legislation, considering that we are dealing with the consequences of the treaty that was entered into by the Philippine government with the U.S. government, and the same pertains to the administration of justice and judiciary. At the very least, with the surrender or extradition of the extraditee, the administration of justice, which we are facilitating in our country, will somehow be affected. So it is the position of the chair that it is but proper that the committee takes jurisdiction over the request of the Honorable Percy Sardanya with respect to the conduct of motu proprio inquiry in aid of legislation with regards to the extradition of Pastor Apollo Quiboloy. The Honorable Vice Chair Dumogan is recognized.
Thank you, Madam Chair. Well, with respect to that point, but as far as the procedure of how the Apo Quiboloy is to be extradited, as I said, at this point in time, it's already covered by our treaty and existing laws. But if our point is to somewhat revisit and see how we can improve or the filing of a proper action to improve our extradition treaty, or on this point, then I agree on that point. Not necessarily connected with the extradition of Quiboloy, because to me, I am sure the concerned agencies will be somewhat knowledgeable to implement our existing laws on this point. Thank you, Madam Chair.
To respond, Vice Chair Dumogan, our discussion of the reported request of the United States government for the extradition of Pastor Apollo Quiboloy will just be incidental to our mandate, which is legislation. Let us be reminded that the request of our colleague, the Honorable Sendanya, is a motu proprio inquiry in aid of legislation. So, for the record, I wish to state, while he mentions about the extradition of Pastor Apollo C. Quiboloy, the same will just be incidental, because our ultimate objective is to respond to our mandate, which is to legislate. With that, I believe that the concern of the Vice Chair Dumogan has been addressed, and for some members who made their manifestations already, it seems that we are in the same direction about the power of the Congress to conduct motu proprio inquiry in aid of legislation Of course, upon the approval of the majority of the members present and with the conformity of the Committee on Rules. Any other member who would like to comment? Meantime, the chair recognizes the presence of the Honorable Congressman King George Leandro Antonio V. Colliantes from the 3rd District of the province of Batangas. Similarly, we recognize the presence of the Honorable Congressman Loreto S. Amante from the 3rd District of Laguna. Thank you for coming. To summarize, earlier, manifestations and comments were made by the members of the committee, and for the information of those who just came, it was raised the following arguments or issues with respect to the existing laws on extradition in the Philippines were raised. One, whether an extradition process may be initiated by a foreign country when the extraditee has pending cases as well in the Philippines. Second, what is the timeline between the receipt of the request by the Department of Foreign Affairs to the transmittal to the Department of Justice? In the same manner, what is the timeline between the receipt by the DOJ to the filing of the petition for extradition with a proper regional trial court? Number 3, it was also raised which court shall acquire jurisdiction over the request for extradition or petition for extradition, whether the court which has jurisdiction over the local cases or the court where the extraditee is a resident of, as mentioned in the treaty and even in PD 1069. The Honorable Chel Jokno likewise shared the two options enumerated in the treaty, which are the temporary surrender and the deferred surrender. By temporary surrender, upon granting of the petition for extradition, the extraditee shall be surrendered first to the requesting party, and upon conclusion of the proceedings in the requesting party, he will be returned to the Philippines to proceed with the prosecution, trial, or even service of sentence in the requested country. By deferred surrender, it means that the Philippines has to conclude first with the prosecution of the case or even the service of sentence in our country before we surrender the extraditee to the foreign country where they will be proceeding with their prosecution or trial. And last question that was raised is, this was raised by the Honorable Flores, between temporary surrender and deferred surrender. It was not mentioned really which or who will be exercising the authority to choose between the two options. Of course, we understand that in the treaty and even in PD 1069, it was made clear that it will be the Department of Justice through the Chief State Counsel who will be filing the petition for extradition. However, once the same is granted, faced with the two options, whether it is temporary surrender or deferred surrender, the question now is, who will exercise the authority to choose whether it will be temporary surrender or deferred surrender? Meantime, we would like to recognize as well the Honorable Congresswoman Eliza Mika M. Gonzalez, Deputy Majority Leader. Thank you for coming, ma'am.
Madam Chair, one last
The
issue.
Honorable Chua is recognized.
Thank you, Madam Chair. Madam Chair, I would just like to know, or if we may add another issue, what will happen to the, what will happen if the extraditee is convicted by the courts of the requesting party? What will happen to the pending case in the Philippines? Convicted po.
That is another gray area in our laws. Ang question po ni Honorable Chua is, what if the extraditee is convicted by the foreign country? According to PD 1069, the extraditee will be returned to the state requested, the Philippines. But the question is, what will happen to the service of sentence imposed by the foreign country? This is another gray area which we cannot see the answer either in the treaty or in PD 1069. Basically, honorable colleagues, your honors, what we are facing right now, I believe, are the ambiguities or perhaps insufficiencies which we see from two existing laws. One is the treaty between the United States government and the Philippine government. We call it Extradition Treaty. And second is the Philippine Extradition Law passed in 1977. Some of the issues were raised already, and apparently the answers could not be found in both laws, which I believe is our mandate to address, for us to be able to improve our existing extradition law. Let us recognize that by treaty, we have obligation to the foreign country, to our contracting party, to abide by the obligations provided in the treaty. However, there are questions which answers could not be found in both laws, and these are the reasons why inquiry in aid of legislation are actually being conducted. So, for the guidance of our fellow members who just came, because I understand we are attending to so many committee hearings, mayroon pong sulat ang ating kagalang-galang Percival Sendanya. In summary, he is requesting that the Committee on Justice conduct a motu proprio inquiry in aid of legislation with respect to the extradition of Pastor Apollo C. Quiboloy. In relation to this letter, we made mention of the two significant laws. That is, one, the extradition treaty between the U.S. and the Philippines, which actually imposes obligation on the Philippines to extradite any person residing in the country who is facing criminal obligations or cases in a foreign country which is a party to the treaty. That is U.S. The other significant law is PD 1069, which was passed by former President Marcos Sr. back in 1977, which is our existing Philippine extradition law. I believe this was prompted by the first extradition treaty that was entered into by the Philippines, and that is with Indonesia. Mas nauna po yung ating extradition law kesa sa treaty with the United States. So, earlier, my dear colleagues, our members already raised various issues which answer could not be found in both laws, either the treaty or the Philippine extradition law, which are the reasons, I believe, why we have to respond to our mandate to address the ambiguities and insufficiencies, and let us remember that this inquiry in aid of legislation, while it touches the issues on Pastor Quiboloy, the same shall be incidental only, and what is primary is our response to our legislative mandate.
Madam Chair.
The Honorable Vice Chair Lagbas is recognized. Before you proceed, Honorable Vice Chair, let me recognize first the Honorable Congresswoman Janice Degamo from the 3rd District of Negros Oriental. Thank you, ma'am, for coming. Vice Chair Lagbas, you may proceed.
Madam Chair, just one last issue.
May I proceed, please?
We have recognized already Vice Chair Lagbas.
Yes, I will yield to Vice Chair Lagbas.
Thank you.
Thank you,
Vice
sir.
Chair Lagbas, please.
Yes. Earlier on, Madam Chair, there was a question as to what will happen if the subject accused is already sentenced or is still ongoing prosecution in the requested country. In Section 2 of the treaty, under temporary and deferred surrender, it provides here, and I quote, the requested state may postpone the extradition proceedings against a person who is being prosecuted or who is serving sentence in the state. The postponement may continue until the prosecution of the person sought has been concluded or until such person has served any sentence imposed. In addition to the manifestation of the Madam Chair, I agree that we should proceed with this inquiry for the reason that this will not be the first case, nor is this the first case, and I believe there will be other cases that the country will be facing. And at this point in time, this inquiry will provide us with ideas on the manner by which the implementing agencies or the subject agencies are trying to enforce the laws, the existing laws. We will know the problems, the Waterloos relative to these issues, and we will be able to find out what should be changed or what should be amended and what should be updated under our existing laws. I believe that it is just timely for us to pursue this kind of investigation so that we will have a clear guidance and all our laws will be updated in pursuing these matters, which I think will keep happening nowadays, Madam Chair.
Chair acknowledges the position of the Honorable Vice Chair Lagbas, and towards that end, in addressing the insufficiencies and the ambiguities, we will definitely be soliciting the help of concerned agencies like the DOJ and the Department of Foreign Affairs and perhaps the Office of the Solicitor General. Your first manifestation actually pertains to the deferred surrender, where if the extraditee is already facing prosecution or is serving sentence by deferred surrender, she has to conclude first serving the sentence before the extradition can be taken action. And what is lamenting about deferred surrender, if we will be waiting for such period of time, the evidence may no longer be available in the United States by the time that the extraditee concluded already the service of his sentence. So that is one consequence of the law which we really have to re-evaluate and revisit visit. Of course, ito pong our efforts to revisit the laws by way of motu proprio inquiry in aid of legislation will definitely be effective in future extradition cases and not with respect to those which are pending already. Any other members who would like to comment? The committee is actually authorized to conduct a motu proprio inquiry in aid of legislation upon approval of the majority of the members present and with conformity of the Committee on Rules. I stated earlier as well that this falls perfectly within the jurisdiction and purview of the Committee on Justice because the extradition treaty produces legal implications with respect to the judiciary and the administration of justice, which is among the mandates of the Committee on Justice. So, meantime, we recognize the presence of the Honorable Congresswoman Laarni Lavin Roque from the 4th District of Bukidnon. Thank you for coming, ma'am.
Madam Chair.
The Honorable Flores is recognized.
Madam Chair, in accordance with Section 2 of our rules governing inquiries in aid of legislation, I move that the Committee on Justice conduct an inquiry in aid of legislation in accordance not only with the request of Congressman Sendanya, but also to cover PD 1069 and all other related laws on extradition, Madam Chair. I so move.
There is a motion
Second, Madam Chair.
to conduct a motu proprio inquiry in aid of legislation on the reported request of the United States government for the extradition of Pastor Apollo C. Quiboloy. I
Second.
heard a second. The same has been seconded. Do I hear any objection? The chair hears none. The motion to conduct motu proprio inquiry in aid of legislation on the request of the United States government for the extradition of Pastor Apollo C. Quiboloy is hereby granted. Pursuant to our rules, the same shall be forwarded to the Committee on Rules to solicit its conformity as part of our requirements to proceed to the motu proprio inquiry. We therefore direct the committee secretary.
Madam Chair.
The Honorable Dumogan is recognized.
Thank you, Madam Chair. In line with our discussion, in order that we will be focused, can we ask the legal research team to come out with the draft that specifically address what had been discussed a while ago, so that when it will be presented, we will be focused on these points and it will somewhat fast track how we can address the said situation. Thank you.
Honorable Vice Chair, I believe that the committee secretariat are taking the minutes of our committee meeting. So for the guidance of all the members, you will be provided with a copy of the minutes of our today's meeting in order that the same may be considered as a tool as well for our succeeding meeting. That will be for the briefing of various agencies to be followed by our initial hearing for the motu proprio inquiry in aid of legislation. That is upon securing the conformity of the Committee on Rules as provided by the rules of the House of Representatives. I understand that we have no other matters to discuss for today's meeting unless there are any other manifestations you would like to make. May I therefore solicit the necessary motion?
Madam Chair.
The Honorable Flores is recognized.
Move to adjourn, Madam Chair.
There is a motion to adjourn. Thank you all for coming. See you on the next meeting. The meeting is hereby adjourned. Tara.